Kia ora everyone, and welcome to our December webinar. We've got with us today Jennifer and Vi, and they're going to be talking about copyright, so I'll just pass it over to them.
Cool, well thank you so much for having us, and it's great to see so many people here to talk about copyright, which is fantastic, and especially in December when you're getting ready for the end of the year. And also fantastic to hear several people approaching us by email to find out if this would be recorded, which it will. So everything that we talk about today will be made available to you afterwards. So please don't worry about taking notes. We're really interested in having a good session here where we discuss with you some issues that have come up for us in a library context, but also taking some of your questions. I guess to introduce us, I'm Jennifer Campion. I chair LIANZA's Standing Committee on Copyright, so you may have seen some emails from me recently. My background is in law. I was in commercial practice before moving to environment. Other people joining us as well, which is great. And so I'm now a subject librarian in the Law Library at Waikato. With me is Vi. Vi is a member of the University of New Zealand Copyright Experts Working Group. She's also the Associate University Librarian and Copyright Officer here at the University of Waikato. Former LIANZA President.
Just we get quite a lot of noise here. I think someone hasn't got their muted, and you might want to do that before you embarrass them.
You can't just set me, maybe disappear like this. No, it's activated. Can we suggest to quite me this
Hi everyone, it's just a reminder to mute your audio if you can. I'm going to try and go through and mute people. That seems to have done it.
All right, so thank you everyone again for joining us. And just a little bit of context, so Jennifer's told you about her background and mine. I think what we're hoping to bring together is Jennifer's legal expertise around copyright and my experience as copyright officer and working with collections, library collections around issues and assumptions that people make, that hopefully between the two of us we can bring these misassumptions, we might say, and the legal aspects together to make it a little bit clearer what we need to do in the libraries relating to copyright. So we're speaking primarily about copying in a library context, and due to time constraints, we're not going to cover the whole of the Copyright Act. We're picking out a few areas where hopefully we can clarify confusion as noted, or give you enough of an understanding to know when and where to dig deeper into the Act. So we'll probably take about 45 minutes and allow 5 minutes for questions, finishing up around 12:50 because we know many of you might be going to the CCANZ event at 1 p.m. But if you've got any questions, just shout out.
Yeah. And also, as some of you may be aware, copyright law is due for reform, and the Standing Committee has been in touch about that. So we know that that review process is kicking off next year, but we do not want to go into that really in this seminar. We're just focusing on some of the issues that we've encountered in our work. But having said that, the LIANZA Standing Committee will be very much engaging with you as part of that review process next year. So do be in touch. Our email address is copyright@lianza.org.nz. And also, just to note, this will be a introductory level seminar. But
do we need that on?
Yep, by all means, do shout out with questions, but this will be fairly introductory stuff. But if you do have ideas about some more specific content on copyright you'd like, do please get in touch, because the committee would definitely be keen to follow that up. All right, so the next thing is just our next slide here that we're just going to move to. Here we go. Copyright Act 1994 there on the screen. So copyright can be a challenging and at times quite intimidating, I think, aspect of librarianship, which is touching on so much of what we do. It's a legal framework that is increasingly criticised as being much more suited to the analogue than the digital age, whereas we're becoming more and more digital in our provision of content and services. So we're negotiating things like licensing agreements, overseeing the relationship between copyright and related library services, and also having to manage our support of things like open access and other policy initiatives. I do think it's important to remember that copyright is affecting us in different ways, depending on what we're wanting to do. Sometimes you'll be copying for other libraries or patrons when you're fulfilling your interloan obligations. Sometimes you're going to want to copy materials in your collection for preservation or digitisation purposes. And sometimes you're going to be considering whether you can use certain materials in your library, for example, by having them as part of a display or part of events that you want to run. So always consider the purpose of what it is you're trying to do, and then look to see whether you have a statutory or a licensing permission or process that allows you to do what you want to do.
Jennifer, before we get deep into it though, what is copyright?
All right, so copyright is a form of intellectual property, which is a generic term for a range of property rights that provide protection for what are collectively known as creations of the mind. Importantly, copyright's only protecting the recorded expression of a work. It does not protect the ideas or knowledge incorporated in the work. So if you had an idea that you wanted to patent, that's the idea that is patented, but the copyright is in the expression of that idea. So copyright will not exist in a work until it's recorded. That's important. And a lot of the arguments in the non-education space are around commercially whether copyright even subsists. Excuse me. So copyright law is granting certain exclusive rights to the copyright holder, who may be the author, but more often is the publisher. These rights are primarily economic, but there has been some recognition of the creator's moral rights to be identified as the creator and a right to object to derogatory treatment of the work. So there's quite a famous case from Canada where there was a snow goose sculpture and the sculptor objected when the mall in which it was excuse me, installed wanted to put Christmas bows on it, which is somewhat apt for this time of year. And that was held to be a derogatory treatment. So it can happen, doesn't happen often, but there has been case law on this. The exclusive rights are qualified by the provision of certain exceptions known as the Permitted Act set out in Part 3, which we're going to go through some of today. So these allow other users to make use of the copyright work, but they are quite specific qualifications. So if you're wanting to copy a work, publish a work, or issue copies of it to the public, these are restricted acts, but they're qualified, so something like quotation is permitted. As can be the making of copies for research and private study. The rights are also different to other rights at law because they are limited for a period of time, typically 50 years from the death of the creator under New Zealand law, after which time the material passes into the public domain.
So just to caution, read the term public domain. As Copyright Officer, one of the things I hear frequently from students preparing their theses, for example, is that they used an image because it was in the public domain. Now often it's...
Hi.
Yes.
Sorry, someone just said they're finding it a little bit hard to hear you. So I wondered if when you're talking, could you, like switch places with Jennifer or maybe...
We'll move it. Is this better?
Yeah,
right.
I think that would be better. Thank you.
So just talking about that term public domain, and there is a kind of common use term that it means people usually mean it's been published, it's out there, anyone can get it. But just be aware that for in the copyright law, public domain has a particular context. And we suggest that you just be aware that your library customers might use this term loosely.
Mm.
Jennifer, you also mentioned the 50 years from death under New Zealand law. But what about material published outside New Zealand? What law applies?
Yeah, okay, so it's often a bit of a tension between what law to use, but in fact, in New Zealand law applies, and it sounds really obvious, but it often isn't as obvious as it sounds to people, and that's because we're increasingly getting a lot of information about copyright from online sources, which may reference US or UK law. So I think it's really important to remember you do need to go back to the Copyright Act, our New Zealand law, and remember that this applies to our citizens, residents and corporates, as well as to those of what are called prescribed foreign countries, so countries that we have reciprocal recognition arrangements with. So really, reference to the law of a foreign country would be if you're publishing overseas, or perhaps accessing material pursuant to license terms that incorporate overseas law. And that kind of feeds into our point shortly about fair use versus fair dealing. But before we get there, let's talk a little bit more about what the Act actually applies to. So we can just change the slide there. Guy, if you'd like to give us some more background.
Okay, just up there we've outlined parts 1 to 6. There are more parts, but these are the main ones that we're going to be talking about. So the Copyright Act for 1994 is the governing copyright law in New Zealand. In order for Copyright Act to apply to a work, the work must qualify for copyright. And qualifying factors are set out in part 1. But the chief requirement is that the work be original. Now that doesn't mean, this is not an artistic standard of originality, but a requirement that the work be original to the author, so independently created and involving the exercise of skill, labour and judgment. Now, copyright subsists for a term prescribed in the Act. Section 22 provides for a period of 50 years from the death of the creator for literary, dramatic, musical or artistic works. But if the work is computer generated or of unknown authorship, it is 50 years from the end of the calendar year in which the work was created. Now, whereas copyright or in a typographical arrangement of a published edition expires at the end of 25 years from the end of the calendar year in which the work is first published. Now, libraries are primarily concerned with Part 3, exceptions or permitted acts, including library provisions from sections 50 to 57A, which we'll talk about more soon. The Copyright Act provides a framework for copying of material, which means that you need to fit your copying within that framework. This means you need to work out what you want to do, what sections of the Act are relevant, and what processes must be followed for your copying to be legal. So you need to ask yourself, what's the reason for the copying? Personal use, for your library collections, for library users, for a class, and then work out what kind of exception you're relying on, and then bring your copying or use within the scope of those exceptions.
Yeah, and you also need to look at whether these works even have copyright in them. Excuse me, to take a drink. So before we get really into the exceptions in detail, we do need to look at, or be aware of, I guess, some of the government material that under Section 27 of the Act has no copyright. But there's a bit of a trick here, because what's protected is the bare text of the work, not the typesetting that the publisher will have protected in their edition layout, or any original material that's included with the item. So if we look at an example now, if I can get the slide to change, where is it gone? Sorry everyone, it's just moved. Here we go. So yeah, so James wants to make a copy of an NZLR law report. Can he do this? And so he goes to Section 27 and he thinks, oh, that sounds like this will answer all of my queries. But in fact, the issue he has is that that edition is potentially protected under typesetting if it's within 25 years from the time it was published, but also any head notes will be original content. So taking those things in mind, he also needs to think a little bit about what purpose he's using it for. So does he want to copy for personal use or his research and private study, which is Section 43? Is he wanting to copy for a class, in which case Section 44 may apply, or the license terms he's copying under? Now, he may want to digitise the material for his class, maybe include it in a reading list, and that's where he would need to consider quite carefully how he's going to do this, because if he wants to get it from print, and if his institution has a license he can do that with, that could work. But if he's wanting to take a digital copy from a database, that's where he needs to comply with the terms of the database. Okay, so just moving on then to the Crown copyright sections. Not all government materials are copyright free. So you've got your Section 27 materials, which are apart from the typesetting aspect and any original content aspect. But then you've also got the Section 26 materials, which are Crown copyright. And these are not exceptions to the Act as such, they're just works that are treated in a different way to ordinary copyright. So in the case of Crown copyright, it's going to endure for a period of 100 years from when it was published, or again with the typesetting protections, 25 years. So Crown copyright is applying to works that are made by a person employed by the Crown or engaged under a contract of service or apprenticeship or a contract for services. But bear in mind, this is just the sort of statutory presumption, so that may have been varied by contract depending on whether or not the Crown chose to retain the copyright or not. So that can come up as well.
So is that used very often?
Okay, so yeah, Vi just asked, is this used often? Not so much today, because most of you are getting more familiar with Creative Commons licensing, and the majority of government publications are now being released through that in line with the government's NZ goal, that's the open access framework. But typically what you're actually finding, or the queries that we're getting, are from people who have older material and they think they may have the only version, and so they want to get that out there for the community. But because it's dating from maybe several decades ago, this is quite problematic, because this is not a Creative Commons situation, this is a Crown copyright thing.
So that happens in my library quite a bit. What do we do about it?
All right, so the first thing is to establish your entitlement to make a copy. So are you a prescribed library under Section 50 of the Act? And if you are, then that's good, that's a good start. Excuse me, but it's by no means the finishing point. So I think you need to think, how are you going to do it under the Act? And so Section 55 becomes relevant for preservation purposes, but that's looking to the availability of alternatives, making sure that there's risk of loss or damage and that you can't access other copies readily. But remember too that it's not necessarily going to be the current terms of the Act that apply, because when the work was created, you're probably talking, if it's several decades ago, from the 1962 Act. So you have to go back to the terms of that Act and look to whether it was made under the direction or control of the Queen or a government department in order to qualify. And that was my point about the fact that departments in the past at times had agreements with the author that the copyright went with the author. So you need to clarify that. And again, that's just that tracing process that we're fairly familiar with when sorting out works anyway. If the item does turn out to be Crown copyright, you need to go back to the original department to work out what terms the item was released on, and that can be a problem if the department has ceased and has been reborn in another context. So there wasn't a standard Crown copyright permission across all departments, so bear that in mind.
But if we do know this Crown copyright, Jennifer, does that give us a license to publish the material? Because a lot of departments government departments do provide for use with fair attribution.
Yeah, they do provide for that, but no, issuing copies of the work to the public is still a restricted act. So you would need a valid exception to rely upon to make that work available, or rights holder permission. So typically what happens is we go through a process where we would need to contact the department and get their permissions. Of course, if the department no longer exists and you can't track them down readily, I guess if the item's over 25 years old, you could contact the Chief Archivist at Archives New Zealand and seek their permission. But also under the NZ Goal framework, you can, if you do know who ultimately holds the permission now, or right to give permissions, you can contact them and try and get the item re-released on Creative Commons licensing terms. So it's not a quick option and not necessarily a certain option, but it is an option, and I think it's worth bearing in mind when dealing with this kind of material.
So another thing, Jennifer talked about New Zealand copyright law and other copyright. You're probably familiar with the US term fair use. Now there is a difference between the fair use provision in the US and New Zealand's term fair dealing. And it's important that you do not assume you have fair use rights in New Zealand. We must here rely on the narrower conditions of fair dealing.
Yeah, and so we then turn to part 3 of the Act, and I think the key thing to note here is that they are more narrowly framed. They're not offering a general framework that focuses on fairness so much as looking, initially you need to find out if you have that statutory authorisation for a particular type of use, and then from there look at whether that use that you're proposing meets the terms of the exception, either by being considered fair in the more broad terms of sections 42 and 43, which we'll talk about use, or within the specific, quite prescribed terms that some of the other sections use. And I think too, remember that the ones we're very conscious of, our library terms, these are not something that everyone can rely upon, and that's where some of our GLAM sector colleagues who want to undertake similar work can't necessarily rely on them the way we can, because they are specific to us as libraries rather than based on the kind of uses contemplated. All right, so we'll now talk a little about the permitted acts, and the point I'd like to really emphasise here is that there are different types of acts based on either the kinds of material to which they're applying or the persons who are going to make use of them. So some exceptions are available regardless of the material they're applying to or the identity of the user. And examples here are sections 42, which is the criticism, review and news reporting section, and section 43, which is the one concerning research and private study that we're quite familiar with.
And that, Jennifer, that's something, sections 42 and 43, that's where the term fair dealing becomes really significant, isn't it?
Yeah, that's where an assessment of fairness does become much more significant, because we're talking there about reasonability of what we're doing. Again, though, I think really important to recognise here, sections 42 and 43 are not library-specific exceptions. They're available to users, and so your role here is really not necessarily in focusing on telling the user what they can and cannot do, although you may get queries, but more being aware that this is sort of them as a user that needs to make that assessment in many cases. I think too, whereas the next class of exceptions are those that can be relied upon by particular groups. So that's your educational institutions and your libraries and your archives. And that captures a lot of the kind of work that we're doing, particularly those who are in university library environments like Vi and I are. Then you have your provisions that can be relied upon under certain quite limited circumstances. So that's your parliamentary and your judicial proceedings, or those that kind of relate to public administration. So, for example, section 59 of the Act provides that anything done for parliamentary or judicial proceedings, it doesn't infringe copyright. So that can be really important if you're in a library where you support your law firm, say, and you're providing court copies of works that will then be used in court. And finally, there are exceptions relating to particular kinds of works, e.g. section 69, which relates to the reproduction of braille copies of books under certain circumstances. And for those of you that may have been following some of the debate around the Marrakesh Treaty that we've been involved in, there will obviously be changes coming as that is implemented, but for the purposes of this seminar, we're just talking about the current law. So it's just worth being aware that there are these rather specific, unrelated exceptions that allow certain uses under certain quite defined circumstances.
Right, but we're going to be looking really quite specifically at library exceptions now.
Yeah, that's right, we are. And the library and education exceptions, they are our focus. But I think it's important to be aware of the other exceptions and where these library exceptions fit within the statutory scheme, because sometimes other things will become relevant to you depending on what you're wanting to do. You might be supporting patrons who want to use material for a variety of purposes, and you need to recognise what the purpose is and what the process is, and that's what the Act gives us. With section 43, for example, we're often supporting users who want to copy. A thing that Vi and I really want to emphasise here is that there is no 10% rule. We hear that quite a bit. No, that's sort of come from Well, what, do you reckon the CLNZ license
Yeah,
is?
I think the CLNZ license is really the only place that I think makes a specific statement about 10%, but it does often, we find that it turns up in general usage with people telling library patrons, for example, that they can copy 10%. So just be aware that's under a specific license. There is not a 10% rule in the Copyright Act.
Yeah. And indeed, the section itself, 43, that they're often using, isn't that prescriptive. It allows for the fair dealing would be for the purposes of private study is not an infringement, but then it gives some factors by which you can assess fairness, including assessing the nature of the work and the part copied, the purpose of the copying, the availability of the work in a commercial market, and the effect of copying in that market. So I think remembering really just here that this isn't your copying as a library, this is the user that we're thinking of here. And that's where it can be really useful to direct them to other resources as well, like the Copyright Council have some quite good brochures on fair dealing, and there are some other links too off our LIANZA website to organisations we work with that can give you some more background.
Just going back, you talked about the administration of justice, stuff. Is that applied very often?
Well, I can't see it coming up for a lot of librarians, but be aware that some, like I guess if you're working in the parliamentary library or as mentioned in a law library context, it could come up for you. Potentially if you're in a public library, because a lot of them do have statutes, you could get a litigant in person type user who wants to make some copies. But just it's good to be aware that it's there and it may come up, even if it doesn't come up very often.
So the education exceptions are really, I think, the important thing for if you're working in an academic library. If you're in a public library, you may be able to call on these exceptions, but they're less likely to come up since they are designed for educational context. But I think increasingly the work of public libraries and other libraries is branching out to include formal classes. So just be aware of these, even if you're not in an educational institution. First, though, you should check whether your institution has a license that applies. If it does, it displaces the Act as the primary source of your rights and obligations in respect to the matters to which the license applies. Use the Act, though, if you have no license. But the advantage of the license is it usually gives you are able to copy more than the Act allows.
Right, so let's say I work at an institution that doesn't have a license by. What would the Act allow me to do?
Okay, well, let's start with section 44. We've talked there about showing sections 44, 49. So let's start with section 44. This allows copying for educational purposes, and it's the source of the 3% or 3 pages rule, some of you all have heard of. This may be useful to bear in mind also when thinking about how much it's fair to copy for the purposes of research and private study that we've talked about in section 43. But this here, the 3% rule actually applies to scenarios typically involving making multiple copies for a class, whereas the researcher in section 43 is a single user making a single copy. For section 45, this says you can copy films and sound recordings for educational purposes. And so you can do this in your class, but keep in mind the difference between making and using a copy in class and then recording it and later uploading it to somewhere like YouTube and sharing it more broadly. Or adding it to your library collection. I mean, sometimes a lecturer may have a DVD, they copy it, they show it in class. We cannot add that to our collection just because it's convenient to do so. Copying under this section is for the purposes of being shown in class. Section 47 allows the performing and playing or showing of works for educational activities, but these must be performed or played by students or staff in the institution to students or staff in that institution. If family members attend performances, then effectively it becomes a public performance and this exception no longer applies. And also, even if you're doing it in your institution for your students and staff, by your students and staff, no charge is allowed to be made for that performance. Now another section, section 49, people sometimes are not aware of this. It's a convenient one. It's for the purposes of examination, so copyright's not infringed by anything done for the purposes of an examination, whether it's setting the questions, communicating the questions to candidates, or answering the questions. So an example for this one, do you want to flip up that, the Jennifer. So let's say, for example, Jane wants to include images from a recent New Zealand Herald sports section in her paper for the class she's been teaching on gender bias in sports images. Can she do this without requesting permission from New Zealand Herald? And yes, she can. This is because of section 49, but that cannot be saved and then later distributed for other purposes other than specifically for that examination.
Yeah, and I think that's a key thing often, is just being aware what the scope of what you want, the permission that you have is, and not exceeding that. It's kind of like you may well be able to download in the court copy example to make a copy for that purpose, but you don't then go, we might need this case later, let's just create a little database in our law firm, and that, just for the future. So it's things like that. It's just knowing the scope, really. In terms then of the library exceptions, having covered the education ones, they're there in sections 50 to 57A, and we are privileged under the Act. There are exceptions that apply specifically to us, and the starting point really is section 50 for a start, because if you're not a prescribed library, that significantly affects the availability of the rights you can have. And so our prescribed libraries are our National Library, Parliamentary Library, District Law Society libraries, libraries maintained by educational establishments, government departments and local authorities, and libraries that are members of the Interloan Scheme.
And this is quite important to know, because while most of us, I suspect, are already working in prescribed libraries, if you are in a library that's not a prescribed library, joining the Interloan Scheme would allow you to become one. And thus the regulations give incentive for private libraries to be part of the Interloan Scheme.
We've just had a question. So Sharon Cornwall asked, if the examination was saved and made available to other members of the institution for use later, is that allowed under the Act?
Not if it's just generic other users, I don't think so. I mean, these are one of these tricky things of what it means, but I guess the lecturer, for example, could save that examination because they might want to reuse it next year, but they're saving it in their own personal thing. But if they're making it available to everyone else in the institution, it could be questionable, what you say?
Yeah.
It's not for that class.
I definitely think the having it behind the paywall makes an impact as well, because I know what we do here at Waikato is that we no longer have copies of old examination papers available in the library, and you can get certain old exam papers made available from what's like the student system, iWaikato it's called here. But even with that, I think if you had copyright content there that you didn't have rights to use outside of the examination context, my understanding is that tends to get redacted, because it's often images or something like that we're talking about, really, that where that can come up. But yeah, so section 53 is the one that you'll...
Sorry, we've had another comment.
Yep.
Richard White said, we've raised exam copies for students' future reference with MBIE for the Copyright Act review, and he said we being Universities New Zealand.
Oh yeah.
Yeah, and I think that's one of the things, what we're all seeing is where the way we're teaching and learning in today's world, the Copyright Act doesn't really serve it well, which is why we're all looking forward to some reforms of the Act. So it just doesn't, I think Jennifer said that, it doesn't particularly align well with today's digital world, and even just the changes in teaching with learning management systems, digital copying, things that we can do. So yes, I think if people have other examples, the copyright, or certainly Jennifer, you'd be happy to collect them into the Copyright LIANZA working group.
Yeah, absolutely.
Yeah, any examples you have of where the Copyright Act just doesn't serve the purpose of, or doesn't support teaching and learning and hinders it, would be great to collect that.
Absolutely.
And just before you carry on, Richard also just said, we do what Waikato does, put past exams behind an authentication system.
Yeah.
Yeah, I suspect that's fairly common across the board for tertiary institutes, and it's often the easiest way around things is that when you're limiting the scope, that often limits the damage for a start if you have infringed, but also it's often something that allows us to get away with, that's not the right terminology, but you know what I mean, that it's a workaround, shall we say. Section 53 authorises us to copy on behalf of users, and so that's kind of in a reasonable proportion of a published edition that can be copied, and that does have that reasonability and that assessment factor there. But with articles, on the other hand, you can have an article, but it's limited to one article from the periodical volume, or two if the works are sufficiently related in subject matter. And that's an interesting point in and of itself, because for some journals they are quite wide-ranging, but for some, every article in the journal might well be sufficiently related in subject matter. So again, this is where it would be, I'm sure, to have a bit more clarity would be helpful. But certainly I think once you're getting into 54 and 56, you're starting to get into the interloan side of things a bit more. So Vi, do you want to tell us a bit about that?
Well, I think probably one of the things I think most New Zealand interloan libraries seem to really have a good grasp on copyright relating to interloan, but just covering that sort of briefly is that copyright is concerned with the making of copies, including digital copies, so the Copyright Act doesn't apply to our lending and sharing the physical books, periodicals, audio-visual works, etc. The copyright for interloan really involves copying for users and collections of other libraries. And this is where digital resources complicate matters, as these are more likely to fall under specific license agreements. So the ability to copy depends more now so much on where your access to these resources come from. You need to check your licenses.
And now we've got another example. So Vi, what about this question?
Yeah, this is one we get asked quite a bit about, and again, I think there's a lot of perhaps assumptions around format shifting. And just be aware that there is no general provision in the Copyright Act for copying or format shifting of films, videos, or DVDs. But librarians can use Section 55 to make collections copy for preservation purposes. But just as you can't make multiple copies of a book because one book's not enough for your collection, you cannot make a preservation copy and also circulate the original. Take the original, put it somewhere into safekeeping, preserve it, and somewhere out of circulation. We'd also like to point out there's no general right to shift format because it's convenient or because you've purchased the item in one form and you want it in another. Section 81A, though, does allow copying, including format shifting of sound recordings, but only from legitimately acquired recordings already owned by the person making the copy, and only for personal use or for personal use of others in their household. Section 81A does not allow the copying of sound recordings held and owned by a library, because obviously the person making the copies doesn't own the recording. However, just to complicate things, for us to always remember all these little bits and pieces, the copying or format shifting of a person's own sound recording by that person in the library using library supplied equipment is not prohibited. So if somebody comes with their own DVD to the library, sound recording,
CD.
Only sound recordings, their CD, and you have the equipment, they actually are allowed to copy it for their own personal purposes.
Yeah. Hopefully they're all using iTunes now, and we can start to get around it. All right, so we're going to talk a little bit about DRM, and the term is used a lot with almost as an entity in and of itself. So let's unpack it a bit. Digital rights management is what we mean by DRM. And yes, as we've all noted, the Copyright Act is overdue for review. In 2008, we had the Copyright New Digital Technologies Amendment Act, but this didn't create a more library-friendly environment per se. What it was trying to do was preserving the balance between copyright holders and copyright material users, as had been struck in the 1994 Act. So,
digital rights management is increasingly relevant to libraries navigating copyright law, user expectations, and publishers and authors emphasising their own rights. The term is often used to describe types of work, but that's perhaps a mischaracterisation. Essentially, DRM is a collective name for technologies or a range of technologies that prevent users from using a copyrighted digital work beyond the degree to which the copyright owner or a publisher who may not actually hold a copyright wishes to allow them to use it.
Yeah, and there are two aspects to this really that we need to keep in mind. There's the technical and the legal, and neither are really sufficient on their own, but in combination can very effectively restrict access and use of content. So often when we're talking about this sort of thing, we're talking about the technical aspects. There's some examples there on the slide. There are a range of techniques typically used in combination. So things like your watermarking, your encryption, your digital certificates, that sort of thing. And then, so what tends to happen is when you've got content that's protected by encryption, there's that validation process where the user's device needs to communicate with the DRM platform and authenticate and allow the access. And that's something where many of us are familiar with. But I think the issue really comes up because digital protection isn't designed to protect the item from any use. It's designed rather to protect against illegitimate access, but also facilitate legitimate access. And so what happens is you've got a system that's quite vulnerable to attack. And as a result, those technical protections aren't enough. And there's been a real push to develop robust legal protections, particularly in overseas jurisdictions.
So DRM is implemented through technical protection measures, or TPMs, which is a broad term that covers many different types of technologies used to control access to copyright content or to prevent users from copying protected content. So content that's protected by a copy protection technology could include movies, games, software, CDs, or digital music files, or even content stored in a protected area on a website. For example, where you have to pay money or enter a password to access the content. There are two kinds of TPMs: access control technologies, so the password protections, payment systems, time access controls, and then copy control technologies, so things like software locks to prevent copying. Generally, access control technologies can be circumvented, cannot be circumvented, but copy control can.
Yeah, and that distinction has come up a lot more in overseas jurisdictions, but it can sometimes be quite relevant in terms of assessing what you can and cannot do. Here, our law prohibits certain conduct in relation to TPMs under Section 226A of the Copyright Act, but here it's qualified by prohibiting the conduct if it would be used to infringe copyright. That's important because in other jurisdictions, it's been held that their laws at times have allowed for circumvention of a TPM for any reason to be prohibited. So it's important that we have that qualification. Section 226D further allows the breaking of TPMs in furtherance of the Part 3 library exceptions. And recently we in the Copyright Committee were asked whether librarians were making use of this provision. And you know, some are, but by no means is everyone. But I think we do need to be concerned that where efforts are trying to harmonise our copyright law to match, for example, the US position, that's where we could see a situation in which the law comes to favour TPMs, even if breaking of them would not infringe copyright. So it is important to be aware of that. And also to be aware that, yes, it is often technically possible for users to obtain high-quality copies of copyrighted works without compensating the copyright holders, but it may not be legal. And that's a challenge that we as librarians often face, is knowing the extent to which something is legal. And with DRM, what you often see is the rights restrictions that the DRM allows for may be less than you would have under copyright law. But we need to be aware of what the legal position is and how proposed technologies or license terms or whatever might be, where that sits, I guess, in relation to the copyright law framework. And of course, that kind of brings us on to the next point, which is really around the contracting out of copyright.
And so we're increasingly reliant on database content in our libraries, which means usage terms are more often determined by license terms rather than copyright law.
Yeah, and licenses are a formal authority to do something which would otherwise not be lawful. And so often we're seeing two kinds of licenses that come up in the digital environment particularly. So what you can get are what are called shrink wrap licenses for off-the-shelf consumer products, for example, software or computer games, something on a CD, and click wrap licenses for content downloaded from a website. These are usually non-negotiable licenses where if you want to use the content, you have to accept the terms. And while there may be statutory protections protecting consumers from having agreed to unfair licenses, generally speaking, we tend to favour freedom of contract here in New Zealand, and so you do have to be aware of what you're signing up for.
Yeah, because the contractual terms agreed by parties takes precedence over the statutory framework. And the trend for libraries, and indeed in copyright law more generally, is a move away from physical acquisition-focused model to a licensing regime in which access is purchased on terms that increasingly favour rights holders. And a risk is that license may actually result in a situation where a user is unable to make full use of the rights they would have under the copyright law, as Jennifer talked about earlier with the DRM stuff. This is because the freedom of contract trumps existing copyright law.
That said, not all licenses are restrictive, and some that may have been brought to your attention are the Creative Commons licenses. And we know many of you may be going to this CCANZ event shortly. So these licenses replace the individual negotiation for specific rights between copyright owners and users with some standardised licenses for reuse where there's, that can be done on the terms provided, particularly where there's no commercial compensation being sought. Yeah, so they can be very useful to know about as well.
And the majority of a library's e-resources are contained in database collections and purchased through commercial suppliers. And just be aware that such databases, the compilations, having the same copyright protection as literary works and are themselves protected as separate works, even if they contain only non-copyright or out-of-copyright material. So copies can be made from commercial databases only in terms of the library's license agreements with the database supplier. So before you decide if you can make copies of content from a database for a particular context, for example, downloading the PDF of an article and uploading it to your learning management system or making copies, just check your license.
Absolutely. Yep.
And your institution may also have a license with a collecting society, such as Copyright Licensing New Zealand, Screen Rights, or One Music, or the Music Society's license that I think APRA, AMCOS, you may be more familiar with those terms. We don't have the scope to go into these in this webinar, but we do want to draw your attention to them. So, for example, are you planning to screen a movie anywhere outside the home? If so, you'll generally need permission from the copyright holder. But in many cases, you can get a public performance screening license reasonably easily to stay within the law. So just keep those in mind, even if you don't have like a subscription to a license. Just check. You may find that it can give you a one-off permission.
Yeah. And then, of course, overlaying all of this is the internet. Now, many of our students or patrons do default to Google searching, and they often find some material that way, albeit of varying quality. And so there's a lot of useful free sites available, but remember, freedom of information does not mean freedom from copyright. And one thing to remind our patrons to be aware of is that there is copyright in most types of material on the internet, and there's an example of the kinds of content in which copyright persists on the slide there now. So yeah, always err on the side of caution, seek permission. If you can't see anything on the website, specifying what the permissions are, and be aware that not everything on the web page they're in a position to license anyway. So yeah, do always err on the side of caution and check.
And I think this is particularly important for libraries engaging with digital content, particularly social media. While it's one thing to grab an image from somewhere and perhaps edit it a little bit for your personal Facebook meme that you want to contribute to, you do need to be more careful if you're working on behalf of your library. There's probably a greater spotlight on libraries and what we're doing now than there was once upon a time. So just check the permissions and ownership associated with that cute picture you might want to add to your library blog, Facebook, Twitter, for example. And remember too that it isn't as simple as taking a photo yourself. A photograph is a work that attracts copyright for the photographer or person commissioning the photo, but it's also a copying technology that can infringe copyright.
So here's an example. What about Al? He wants to use images he's sourced from Google in his lecture. Can he do this?
Well, he can use them in his class, but not in a public lecture, and that's under the educational provisions. And his lecture or class cannot be recorded, or at least you can't include the images in that recording, which is then if it's going to be further shared beyond the class or beyond your university's firewall, for example. But Al could and should check what the rights are on the actual images. The first thing to note is that Google is mostly not the rights owner. Another thing I get a lot from students as Copyright Office, particularly when they're talking about their theses, is it's Google's images. They just use Google images, but the images are not Google's images. And it is really important that patrons be encouraged to go back to, it is, as most of us I think realise, it's a list of the Google images, brings us a list of images as a result for our search, but it's important to go back to the page and the image to check the rights.
Mm. Yeah, now that really brings us to the conclusion of what we can cover in this webinar. But on the screen now is the LIANZA copyright resources page and a link there. We do want to draw your attention to it because there's a lot of content that the Copyright Committee members over the years have put together. It's very discoverable. Just search LIANZA copyright resources in Google and it will take you right there. And remember that also we are very happy to take your questions, copyright@lianza.org.nz. And as I said at the outset, this is very introductory material, but if you've got more things that you'd like resourcing and support on, do let us know because we'd be very happy to put something together for you.
And I think as copyright law, licenses, contracts is complicated, and we would like it to be more black and white. Unfortunately, it's not. And I think as librarians, it's almost so much easier if we had rules that we could just follow. But what we just, unfortunately, that's just not the case, really. You have guidelines, perhaps more. But, and as librarians, we really want to resist the idea of being the copyright police. But we are an intermediary between patrons and the law, and notices explaining the legal restrictions should at least be provided at self-service photocopiers, printers and scanners. Libraries also need a compliance program to ensure that the conditions are being observed. But we would just say, I guess in closing, is avoid providing advice on what people can copy and how much they can copy. You don't need to be the bad guys enforcing the rules. Rather point your users to relevant regulation or copyright guides so that they can make a decision appropriate for their own copying context.
We've just had another question as well from Rebecca. She said, for student thesis, do you check all their images or is that the responsibility of the student? Don't worry, she just said, I think you've answered it.
Yeah, their responsibility. Yeah, but you know, I mean, people ask for guidance. You know, and I think that's where you need to have, just some guidance available to them. I do find with students that handing them that the Copyright Council's fair dealing brochure is quite helpful.
Yeah, what I found too is that Vi and I did a doctoral writing conversation session with some grad students here. And I find there's a lot of confusion, particularly with the international students, around the distinction between copyright law and plagiarism. And so they get very hung up on the academic integrity side of things. That's obviously been hammered to them at some point previously, but then they sort of want to get into that versus copyright, and you sort of have to explain that it's different things going on. I mean, sure, there's overlap, but just tease that out a bit for them.
And I think one of the main things is we remind them, particularly, for example, our students' theses go in our open access institutional repository, so it's mine, but they are really effectively publishing their thesis. So they have to consider any copying of copyright material that they include in their thesis, they are publishing it, and it's very different from private research or study.
So CJ has asked a question. My public library owns a print copy of a parliamentary report to the secretary on the inquiry, but it is in very poor condition. Can we digitise this, put the print copy in restricted access and post the digital copy to a library database, view not download, without first seeking Crown copyright or other permissions?
All right, so the issue there is with the digitising and the copying, and just going back to what we covered off in that section, you should be able, as long as you're not, like you couldn't just chuck it up on your website and make it available that way. But if what you're doing is making essentially a digital copy of a from print, you have the right to do that in the format shifting provisions under Section 55 of the Act. But then it's just how you're going to make it available to patrons, and that's where having that ability to come in and see it, as you say, make it not downloadable, make it viewable in an offline repository type scenario, that should be okay.
And Jane also said, thanks, really interesting presentation.
Oh, thank you very much, and thank you everyone for coming. It's great to have people engaging on copyright, particularly as we go into a review, and hopefully we can get some more of these sort of sessions and start to sort of tease out other parts of the Act in future, because I think that would be something that we all probably need to school up a little bit more on.
That sounds great. More people are just saying thank you, great webinar. So I think, should we just give it a couple of minutes in case someone has a question, and then we can wrap it up.
Absolutely, and anyone that needs to go, please do. We know that the next event's coming up and you'll want to get ready for it.
Or people just might want lunch.
Yeah, that's true.
Okay, lots of people are saying thank you and they're looking forward to the next one, and have a nice Christmas. Lots of thank yous.
Thanks to all of you. Have a lovely break.
Cool. All right, I'm just going to stop recording now, and then we can have a chat later if people want to stay. Okay, thank you for coming.